In 1985, this law was introduced called Anti-Defection Law, and the object of this law was to counter the frequent cases of the political party members, the members of parliament or state legislatures belonging to a political party. There were cases that they frequently changing their alliances. So to counter this law was introduced. So to understand this, if A belonging to some political party, you can say Congress, and if he joins BJP, either he joins or he votes for BJP, or he you know abstains from voting in favor of Congress, so there may be some advantage to BJP. So by this law, some articles and one schedule 10 was introduced. So this schedule provides how a member of the parliament belonging to a political party due to the reason of defection can be disqualified from the house of the whether it is house of people of states, state legislative assembly or councils. So as a provision of anti-defection law under the Constitution applies equally to both the union and state. So the member defecting either in parliament or any state legislature, that member defecting can be removed by the presiding officer after the charges of defection are proved. So we will discuss the whole law provided under the Constitution. What is defection? What does defection mean? What are the provisions? What are the grounds or the relevant laws? Already, as I said, that the anti-defection law was introduced to disqualify the members of the parliament or state legislature on the ground of defection and limiting the opportunity of members to switch political alliances. So the main object of the law was to disqualify the members of the parliament or state legislature belonging to a party, and just because they have changed the alliance, and obviously when a party member changes the alliance, that means they are no more believing in supporting their original party. So that's called defection. And in simple terms, we can say that when a member belonging to one alliance supports another, that's called defection. And there is a rebellion in that movement by the member, that he decides that he doesn't want to support the original party whom he originally belongs to. And obviously in practicality, that when a member of a party gets offered some benefits, some offices, some remunerative benefits, and there are certain allurements by the another party, and that attracts this member to join that other alliance. So most of the times these promises are there when an individual member of or members of the party are defecting from their original party to another. So this is called a defection in simple terms, but there are other grounds given under 10th schedule for disqualification. So whenever this happens, that a member defects, then he obviously is moving away from the party, or doesn't want to support the party whom he originally belongs to. In that case, if he is removed from the party, then he is also disqualified from the membership of the house of the legislative assembly of the states or parliament. So when a member of political party joins another party, it's called defection. But also when a member votes against the whip of the party, as there was decided by the party members that every member has to vote according to the decision taken by the majority of the party, and that member violates the whip of the party, and there is obviously an implication that he might want to support the opposition, or that person doesn't want to do anything just because there may be some indirect benefit may be given to or may availed by the opposition. So in those scenario also, this is somehow called supporting the opposition, then it's definitely defection. So that can also be a ground for defection. Now, object of anti-defection law is to support that there must be stability in governance, because this is very obvious that if members of a political party again and again switching the parties, and there is obviously majority rule that which party establish the majority in the house and gets more seat, then obviously there is a governance of in hands of that party members. So if defection is happening again and again, and there are frequent cases of defection happening, then there will obviously be instability in governance. Then comes the sustaining the faith in electorate. So this is very obvious that democracy is not just written there and we are living in a democracy. Obviously, there is election procedure, election every 5 year. Whoever gets majority forms the government. So if the members, a party having a majority, and some of the members of the party defects and joins another alliance or leaves the party even without joining any other alliance there, and there are some reasons, promises, benefits to that member and whatever, but if it happens in such scenario that the government may fail, the majority may fail, and another party may establish this majority, for which there is a obviously a procedure of the house under which the floor test is to be done, wherever there is a majority shaking and another party claims the majority, and in such circumstances there is a floor test to be done. And so ultimately, what if the government voted, the people of the country voted to support A party, and then some of the members of A party joins B party, and making successful formation of B party government. So ultimately the people of India voted for A party, but some of the members defected and joined B party, and ultimately what government, the people of India wanted that party A must be in power, as it has worked properly, it has proved themselves to be the party working in the favor of people, for the benefit of people in their growth. But ultimately some of the people defects, and for which they are are promised some offices, some remunerative benefits, awards to be given to them afterwards. So in such situation, ultimately what's happening, it's the electorate getting cursed. Ultimately the people are in such situation, people would lose faith in elections itself. So obviously our country, our democracy would be at stake. Then maintaining free and fair competition amongst political parties. So if A party members joins B party members, okay, A party members join B party. In such a situation, this is a case where ethically this is not a fair competition between both of them, because if B party approaches A party members saying that we promise you that we will give so and so position to you, so and so remunerative post to you if we form government. In this scenario, this is not a fair competition, and that's why this law was also necessary, because ultimately if a group of people attracting some people in another group, that's not a fair competition. Now, as I already stated, that 52nd Amendment 1985, through this amendment, this Article 102 and 191 was amended, and in both of these articles, a clause to that effect was added, and also 10th Schedule was introduced, in which the procedure how the disqualification will be there on the ground of defection is discussed. This law is applicable to both Parliament and state legislatures. And then in 2003, 91st Amendment introduces some changes further in these provisions of anti-defection law. So 10th Schedule mainly was amended with this Amendment Act. Now, Clause 2 under Article 102 and Article 191 were added, and it provides that a person shall be disqualified for being a member of either House of Parliament if he is so disqualified under the 10th Schedule. So the provision provides that disqualification is there under 10th schedule, then the membership of the person shall also be taken away, and he'll be disqualified from being the member of the house as well. So the same provision is there under 191 clause 2 with regard to legislative assembly or legislative council of the state. Now there is a 10th schedule, as I stated earlier. That 10th schedule provides the procedure for disqualification on the ground of defection. So the category 1 of disqualification is of political party, a member of political party. A member of political party belonging to a political party becomes disqualified from house on following grounds. So if he voluntarily gives up his membership of such political party, and if he votes or abstain from voting contrary to directions issued by the party without obtaining prior permission, and the same has not been condoned. So if he has voluntarily given up his membership, that's also a sufficient ground for disqualification. And if he votes or abstain from voting contrary to direction issued by the party, and party without party's permission, and the same mistake by the violation by the member has not been condoned by the party, then in that case defection is attracted. One thing to be remembered is that defection is not automatic. It's obvious that you have to file a petition before the presiding officer, as we will discuss that the defection petition is to be filed before the presiding officer, that may be speaker, chairman, or either of them of the house accordingly. And on that petition there would be hearing. The principle of natural justice will be followed, that person would be heard, and after all of these proceedings, the decision, if there is a decision that a member defected the position and he has done so, he changed the alliance or did not support the political party at the time of whip, then in that scenario he can be declared to be disqualified as under the 10th schedule. Then ground number 2 is disqualification of independent member. So an independent member of house becomes disqualified if he joins any political party after being elected, and that means that an independent member means that he is not belonging to any political party. He has fought election on his own and won independently. But if that member, after winning the election, if he joins the political party, that means he is defecting his that character, independent character. So that is also a scenario where the defection can be attracted. Then the disqualification of nominated members, as we know that there is provision for some number of vacancies. The seats are there for nominated members in the house. So if those nominated members becomes disqualified if they join any political party after expiry of 6 months from the date of taking seat. So this is to be remembered, that after 6 months, if they join any political party, that attracts defection. But if they join political party within 6 months of their taking seat in the house, that will not attract defection. So this is to be remembered, that there is a period of 6 months within which they can join political party without attracting provisions of defection. Then comes some exceptions of general rule of defection. And exception 1 is under para 4 of the 10th schedule, and it provides if a member joins another party due to merger of the party with another party. So if there is a merger between the parties, and that merger takes place amongst 2/3 members of the party, in that scenario, that defection is not, the provisions of defection is not attracted, and that this exercise is completely exempted from the charges of defection. But that must be amongst 2/3 members of the party, and that must be a merger between the parties. Then there is another exception under para 5 of the 10th schedule. It provides, and then second exception is provided under para 2 of the 10th schedule, and it provides that if a member is elected as a presiding officer of the house, that means the speaker or chairman of parliament or state legislature, in that scenario he gives up the membership of the party, and then after ceasing to be that presiding officer, if he does not join that party again, or if he joins that party again, or if he does not join either the same party or any other party, or if he joins the same party afterwards, all of these things does not attract the charges of defection, just because that object behind the giving up the membership was that the election as a presiding officer. There was a provision of split under para 3 of the same schedule, and it provided that used to provide that if 1/3 member of the legislative party agree to split and they move away splitting from the rest of the party, in that scenario the defection was not attracted. So but this split rule was removed by 91st amendment of 2003, and this rule is no more in effect. Now comes the question as to who will decide and whose decision shall be there with regard to disqualification. So disqualification question be referred to with regard to disqualification to Speaker or Chairman of the House, and that decision shall be final as provided in the 10th schedule. And whenever a question with respect to disqualification of Speaker or Chairman comes, then the question shall be referred to a member elected by House, and that member shall decide that whether defection is there or not. Disqualification would be the consequence or not, that member will decide, and the decision of that member shall be final. So in general, the question as to disqualification is to be decided by the presiding officer, and that is a Speaker or Chairman, and that question shall be final. And with this regard, there was a challenge in a popular case named Lohan, and that case, in that case, the whole 10th schedule was challenged, its constitutionality was challenged, and in that case it was decided that decision shall be final how this term is to be interpreted, whether if this decision is final, no petition before the High Court or Supreme Court can be filed after the Speaker or Chairman has decided with regard to defection. And then this in this case it was held that paragraph 6(1) of the 10th schedule, to the extent if it seeks to impart finality to the decision of the Speaker Chairman, is valid, but the concept of statutory finality embodied therein does not detract from or abrogate judicial review under Articles 136, 226, 227 of the Constitution, insofar as infirmities based on violations of constitutional mandates, malefites, non-compliance with rules of natural justice, and perversity are concerned. So on those grounds, the challenge can still be made as per the decision in this case, that judicial review cannot be taken away, even if this decision of Speaker or Chairman is stated to be and provided to be final. And then one thing further was stated that paragraph 6(2) says that a 10th schedule attracts an immunity analogous to that in Article 122 and 212 of the Constitution, and that provides that these proceedings shall be the proceedings in Parliament, and they are immune from the any sort of challenges before the courts of law. And for that it was held that the validity of proceedings from mere irregularity of the procedure, and that protection under 122 and 212 is to protect the validity of proceedings from mere irregularity of procedure, and confines the scope of the fiction accordingly. So it says that protection is that when there are irregularity in the proceedings, that is protected, but otherwise the biases, the violations of natural justice, malefites can still be challenged, and they are subject to judicial review. So this is to be remembered, that even if the decision of Speaker is final as per 10th schedule, but still that can be challenged on those grounds. But one thing is also important to understand, that there is a decision of Honorable Apex Court. I could not produce the judgment, but it was held that when a disqualification is going on and a member, the charges are there, that question is to be decided by the Speaker or Chairman itself. That decision cannot be taken by the courts. So whenever a petition for defection, the allegations of defections are there, that the petition should be filed before the Speaker or Chairman, and then in between that, there cannot be any challenge before the courts of law unless the decision has been taken by the Speaker. And after the decision, if there is any perversity, malefites, violation of natural justice, that can be challenged before court. So a court cannot play the role of Speaker or Chairman. And it was stated that if chairman or speaker does not take proper steps in such a petition of defection on the grounds of defection for disqualification, then one can file a petition before High Court or Supreme Court, taking this direction that speaker must act towards those petitions if those are withheld or not, if the speaker is not proceeding with those petitions. So that can be done. Then comes a para 7, which provided that no court shall have any jurisdiction in matter with respect to disqualification of a member of House. So this para 7 was also challenged, and it was held unconstitutional, as a judicial review is a basic structure, part of basic structure of the Constitution, and the same cannot be taken away by any provision. So it was held that the presiding officer, while making a decision about defection under 10th Schedule, it functions as a tribunal. Therefore, his decision, like other tribunals, is subject to judicial review on grounds of arbitrariness, malafide, gross error, as we have earlier discussed in earlier slide. So judicial review, it was held that the para 7 is invalid for want of ratification. So one more thing is was there, that as per 368 clause 2, the ratification from half of the states were required before passing of this law of taking away the jurisdiction of the High Court of Supreme Court, but the ratification was not taken by the before the passing of this law. So by that reason also it was not valid. So this was also held in Quixote Holohan judgment, and the judicial review, the jurisdiction of the courts was barred. That clause was held unconstitutional. So this was para 7 of the 10th Schedule. Now there was another amendment took place, which was 91st Amendment 2003, as I have discussed earlier that this split rule was removed by this amendment, in which if one-third members of the legislative party were splitting from the rest of the party, they were protected from the charges of defection. But now this rule is not there, and it was removed from this amendment, an amendment of 2003, which is 91st Amendment. And also in these articles, these clauses were added. So under Article 75 and 164, total number of ministers including PM at union and CM at a state, it was held that it will not exceed 15% of the total strength of Lok Sabha or Legislative Assembly of state. So 15%, say that cannot exceed 15%, the number of ministers. And in state legislature, it was held that it was added that not less than 12 ministers must be there in the state legislature. So this was to limit, as there were occasions seen where there are number of ministers, unwanted number of ministers working at a very unnecessary strength. So to get away with such circumstances, such situations, this provision was added. And then also Article 75 1B and 164 1B was added, and it was provided that a member of either House of Parliament or state legislature who is disqualified on the ground of defection shall also be disqualified to be minister till the expiry of his term or until his re-election, whichever is earlier. So if member is disqualified due to defection, and that if he is disqualified, then in that case he can also not be a minister, and that goes on until the expiry of term, or if before expiry of the term, if he is re-elected, until that re-election. So this is also entered or added by this Amendment Act. Now 361 BA was added. In this Article 361 BA, it was added that a member of either House of Parliament or a state legislature belonging to any political party disqualified on the ground of defection shall be barred to hold any remunerative political post. Offices like any office which is remunerative in either in state service or union service. So these were the provisions, the changes introduced by 91st Amendment, and those changes were mainly with regard to the law of defection. There were many committees and their reports were published in which the committees has given some important suggestion with regard to this law, and these committees since the very beginning of this the want or struggle to introduce this law to present time where further changes are suggested by different people and committees. I have reproduced some of the important suggestions given by the committees. I'll not be discussing it, but I'll share the slides so that you can read, and if any suggestions, if you find, you must see that what suggestions were given by the committees and actually were added to the provisions, and that can also help in understanding this, that what further changes are required for future under 10th schedule. So these were the important committee reports of with regard to 10th schedule, the anti-defection law. Now comes some important judgments with regard to, we have already discussed the key issues in Kyoto Holan, what was held in Kyoto Holan. Now there are some other judgments which are equally important. So in Srimant Balasaheb Patil, in this judgment, the issue was whether resignation before charges of defection can protect a member from charges of defection. And second issue was till what time period a member can be disqualified. So it was held, it was the issue that whether resignation before charges of defection, in that case, if before charges of defection are imposed and that member resigns from the membership, whether he'll be protected from defection, allegations of defection, the charges of defection or not. So it was held that disqualification relates back to the date when the act of defection takes place, right? And a pending or impending disqualification action does not become infructuous by submission of the resignation letter when acts of disqualification has arisen prior to the member's resignation letter. So it was held that if the act of defection had taken place before resignation, and even if the resignation is opted prior to the procedure taken place with regard to defection, in that case even the defection can be there and disqualification can be made. Now, second issue before the court for adjudication was that till what time period a member can be disqualified. So the speaker is the authority who can disqualify a member, and that disqualification cannot be till the end of a term, which means that if a member is re-elected before his end of term when he is disqualified, then the disqualification would be up to that time period only when he is re-elected, not until the period of his end of term of his previous election, So that means that the speaker is not empowered to disqualify till the end of the term. So either the end of the term or re-election, whichever thing takes place earlier is the rule. So it's not like that if he's re-elected before the end of the term of his previous election, then he can hold the offices there, remunerative post or political post, being can be a minister after his re-election, even if that happens before the end of the term of his previous election. So this was clarified. Now, second important judgment would be Rajendra Singh Rana and others versus Swami Prasad Maurya and others. This is the citation. Now, issue was in this case that extent of exercise of judicial review by courts. So, what is the extent of judicial review which can the High Court and Supreme Court exercise? So, it was held that in following cases, judicial review can be exercised other than those which was already decided in Holohan case, where the judicial review can be made, judicial review can be there of these disqualification proceedings or not. So it was held that yes, judicial review is also always open when it is on the ground of mala fides, arbitrariness, the violation of natural justice. So other than that, in judicial review, up to what extent the courts can entertain the pleas. So it was held that when the speaker fails to act on complaint of defection, in that case judicial review is allowed. The courts can interfere, and then also when the speaker accepts the claim of splits or mergers without any finding and reason. So just to protect the members, if wrong claims of splits or mergers are accepted, as splits is now not in existence as it was removed in 2003 amendment, but as the merger is still there provision, in case where the wrong merger propositions are made and the speaker blindly accepts the explanation, then in that case courts can interfere. When the speaker fails to act in accordance with the 10th schedule, so it is as it was held in Lohan judgment, that the speaker acts as a tribunal, and if he fails to act as a tribunal, as any other tribunal has to act according to the constitution and the laws, then in that case courts generally interfere. And even in this case, in this scenario as well, where the speaker is supposed to act according to the 10th schedule and he is not, then the Supreme Court can or High Court can interfere. So these were the key grounds or situations where the courts can also exercise their power of judicial review. Third important judgment would be Jagjit Singh versus State of Haryana, 2006, and this is the citation. An issue was when independent member can be disqualified on defection. So issue came in with regard to, there were some doubts about the independent member being alleged to have defected. So it was held that to determine whether an independent member had joined a political party, the test is to be considered was whether he had fulfilled the formalities for joining a political party or not. So if he has done some formalities, the circumstances are showing that he has fulfilled the formalities to join the political party, that means he has joined it, or he has this intention of joining this. Then giving of outside support by an independent elected member is not the same thing as joining any political party after election. So this is to be remembered on the context of independent member, that outside support by an independent elected member is not the same as that of joining any political party. Not a direct support, but outside support by independent member cannot be such as to joining the political party. So this is to be remembered. And thirdly said that the test is whether he has given up his independent character on which he was elected by the electorate. So there must be something showing that he has given up his independent character. In that case, it can be defection. As we have already discussed, that independent member can be disqualified on defection if he joins a political party. That doesn't matter that which political party he joins. He can join any political party and can be disqualified. But whether he has joined or not, that is to be tested properly, and for which this judgment was there and it was held as we have discussed. So thank you so much for watching. I hope I have done it well. If you liked it, please subscribe the channel and like the video. Thank you.